Aloha, this is Professor Porter. We're talking about prior statements, and essentially all of trials involve prior statements from witnesses. If you think about a civil case in particular, almost everyone that's going to testify and appear as a witness at trial has given prior statements. Most oftentimes they've given formal depositions under oath with both parties present and counsel present. Other times they give statements to investigators at the scene. They give statements of many different forms along the way in the timeline from the events that are the case until the trial of the case. What I think often gets confused with people new to evidence and students learning evidence is how do we use and what can we do with these prior statements? And the first thing I want to talk to about, and I want to introduce an analogy that has to do with ice. The first thing I want to talk about is that you cannot start trial and start in trial by referring to prior statements. If you have a witness that talked to an investigator at the scene of a car accident, and at trial you have that witness on the stand, you can say, Mr. Witness, what did you see at the time when the light was turning red? It's a contemporaneous conversation you're having with the witness. They're reciting it for that jury at that time. No objection, at least as it relates to hearsay. If you all of a sudden switch the phrasing of that questions to what did you tell the investigator about what you saw at the scene? Objection, hearsay, sustained. So it's a big difference. You are not permitted to go to prior statements to assist in the testimony right here. You're supposed to have a contemporaneous conversation with this witness about their personal knowledge. And so think about it in terms of an ice analogy. There's a couple different instances when we get to go back to the refrigerator, go back to get ice, and help someone along or use the ice in a different way. But you don't get to start out with the ice. You don't get to, we're hoping that you can just provide testimony, provide the drinking water as you go, because we're having a contemporaneous conversation. Here's three different ways, at least the three most prominent ways that we would think about prior statements factoring into this trial. One is a hearsay exception, former testimony. It has to do with when the declarant, the person who gave some type of former testimony at a hearing, proceeding, or deposition, they laid it fully out. They had a full direct, they had a full cross, they had a full redirect, they had exhibits, they had the whole testimony at some other time. And now they're not here for this trial, they're unavailable for this trial, and we would turn to former testimony exception under 804B1 because they're unavailable under 804A and because their testimony was some type of suitable substitute for them showing up live and in color during this trial because we had the same counsel there, or we had a predecessor and interest counsel there, they had the same opportunity and motive to develop cross-examination, and we're able to sort of take that testimony and put it in this trial. That's one use of a prior statement. And notice that's everything the person said at the prior hearing or proceeding or deposition. The next two are more narrow. With the right foundational requirements, essentially someone testifying, most often on cross-examination, they testify inconsistently, or you're going to explore an inconsistency with their prior statements from what they testified on direct. And on cross-examination, you're going to ask them again, hey, weren't you asked questions on direct examination about the color of the person's shirt that was at the intersection? Yes, I was. And you answer the color of the person's shirt was blue. So you're locking them into their testimony today at trial because you know one of their prior statements, whether it be in a deposition or a statement to the police or a statement to an investigator, one of their prior statements had something inconsistent. It said the person's shirt was green on a prior day. So prior inconsistent statements, whether in any form under 613, you can ask someone questions. It's not hearsay. You can ask questions about inconsistency, and it's not hearsay because you're not offering it for the truth. You're offering it to show that someone says different things on different days. And in limited circumstances, you might even be able to get it in as not hearsay. And the bonus of that is you'd be able to use it for impeachment and call someone a liar in closing, but you'd also be able to use it for the substantive truth, for substantive evidence under 801 D1 if you meet the foundational requirements of the prior inconsistent statements there. But you're talking about limited instances where they testify inconsistently just as to the shirt color. We're able to go back in the freezer, get a couple ice cubes that just have to do with that narrow testimony and use them in the way that I'm going to suggest. And lastly, usually with our own witnesses, the witnesses that we call when we're the proponent, when we're the one presenting evidence, will occasionally not remember things, will not remember aspects of their own testimony that they did in prior statements. They'll say magic words. Where were you on the day of May 23rd at 9 o'clock? I don't remember. And just like the inconsistency of blue shirt versus green shirt with inconsistent statements, refreshing recollection is I don't remember starts that witness along the foundational requirements for refreshing someone's recollection. I too get to go back in the freezer, get a couple of the ice cubes that will help refresh that person's recollection and get them back on track in their testimony. So this is to say, I can't start with someone's prior statements without more. There has to be unavailable, and I'm using it for former testimony exception. Maybe they've testified inconsistently, most typically on cross-examination, and I'm going to use those prior statements against them. Or maybe my own witness on direct examination has said the magic words I don't remember, and I get to go to the freezer of his prior statements, pick out a few ice cubes that can help refresh his recollection. So former testimony, one of the ways I want you to think about it is a big honking ice cube. It is the entire testimony. What we're trying to establish is that this person is not available and they did this at some other time. They did this at some former time. We're in trial number 2 of a criminal case. And in trial number 1, we had a particular witness. We had a witness that was on the scene, that saw things, that testified, had a direct cross-examination, a redirect examination, and they did the full-blown testimony. That trial number 1 resulted in, let's say, a hung jury. So there was no result, no finding of guilt, no finding of not guilty. It was a hung jury. The jury couldn't decide. That jury is excused. We come back for trial number 2. Between trial number 1 and 2, that witness, that percipient witness who was there to talk about what happened at trial is no longer here. They are unavailable, which you have to be to use former testimony under 804B1, because you have to be unavailable under 804A. So that witness is unavailable. Can we take the big chunk of their testimony and move it from trial number 1 and plop it into our trial number 2? That's what former testimony is about. So it is not something that the courts take lightly. It's not something, frankly, that the rules allow readily. It has significant foundational requirements that we cover in other videos, but here they are. So we not only need the witness to be unavailable for one of the reasons accepted under 804A that are listed on the left side here, and we can't talk about former testimony or using former testimony unless we establish unavailability and the court accepts it. But then it has to be the declarant had to be there before, they had to testify at a deposition or a hearing or proceeding under oath, and most likely the same parties were here. In a civil case, it has to be real similar parties in privity with one another. And even if we have that prior proceeding, it has to have the same opportunity and the same motive to develop testimony on cross-examination. We're going to be real strict with when we allow people to pick up that big honking ice cube and bring it from one proceeding, one deposition to the next. And we're certainly not going to allow it if it's grand jury, because there's no defense counsel there. We're not going to allow it in other types of criminal proceedings if there's not the same motive or opportunity to develop testimony on cross-examination. Then we get to prior inconsistent statements, and I mentioned earlier that's we're on cross-examination and they testify inconsistently. They said that the officer's testifying on direct, and he said he got to the scene around a little after 8 o'clock. I have a statement in my hand, I have a prior statement in my hand that says that he got there at 7:45. Those two statements are inconsistent. So I'm going to engage in questioning that's going to establish that those two things are inconsistent. And if he just said it in his reports, and he just said it in a prior statement, I'm going to lock him into what he said today. In your direct testimony today, you said you showed up just after 8 o'clock. Yes, yes, yes. And didn't you give a prior report? Didn't you give a statement in this case? Wasn't that closer in time? Didn't you have something to say about when you showed up earlier? And get 7:45 and sometime after 8 up on the screen next to each other so we can say that this person says different things under different days under equally reliable circumstances. But notice what I'm doing as it relates to the ICE. I have a whole ICE chest, all broken up into little ice cubes, all representing the former testimony, all the things that this witness has said. And I'm able to go back and hopefully with the assistance of my co-counsel, go back into that ice chest and grab a cube or two and say, yep, you know what? We're going to pelt this witness during cross-examination with the few ice cubes that represent the inconsistency. I'm going to throw the 745 ice cube at him. I'm going to make sure that through my questionings, I demonstrate different things on different days. And I'm going to illustrate that pelting them with ice cubes for the jury so they know this person is saying something different to them today than they said under equally reliable circumstances before. So I'm not taking the whole testimony. I'm not taking the big honking ice cube. I don't have these vast foundational requirements about the validity of their opportunity or motive to develop cross-examination before. None of it. All I have is an inconsistent statement that I'm able to bring out. And just think, inconsistent statements can be two varieties. If the witness said it in an email to a friend, I can still take out those few ice cubes and pelt them with, but it just means that I'm only going to be arguing credibility. I'm only going to be using it to impeach. When I return to this point in closing, I'm going to say, remember that the person said different things on different days, and you shouldn't believe them as to this item and their other items. So I want to use it only for an argument to impeach. If they offered a prior inconsistent statement in some fancy proceeding, in some proceeding where they were testifying and subject to cross-examination, they testified in some earlier proceeding, some earlier hearing, and it qualifies under 801D as a prior inconsistent statement. When I get that ice cube in, when I get that particular evolution of pelting them with an ice cube on cross-examination, I may be able to use, if it satisfies 801D, that statement not only to argue credibility, not only to argue that we've impeached this person, but also the prior statement can be used for substantive evidence. That is, I can argue the truth of that prior statement. I can argue the truth of 745. I can argue the truth of green shirt if it was said in the right circumstances. But notice, I'm only going back there to the extent this witness on game day testifies inconsistently. If this witness shows up and eats it and says, you know what, it was a blue shirt. You know what, I showed up at 7:45, and that's all consistent with prior statements, I don't have the opportunity to go to my war chest. I don't have the opportunity to go get individual ice cubes. Only when they stray, only when it's inconsistent. And then lastly, I like to think about refreshing recollection. These are our witnesses. These are, when we're the proponent, we're calling our witness or sponsoring witnesses. And as much as we want to prepare them, as much time as we spend with them to get their testimony right, they're going to drop things. They're going to say, I don't remember to certain things. That's the foundational requirement. I don't remember. And just imagine they have that glass of water in front of them as they're testifying. And if they say, I don't remember, and they look down, and they just have this warm half cup of water and they can't deliver what you need them to, you also get to go to your war chest. You also get to go to that witness's prior statements. And actually, with refreshing recollection, you can refresh their memory with anything, as long as it's something that can trigger their memory on this point. So you go back, you get a couple of ice cubes, you establish after the magic words of I don't remember, hey, we're looking at your statement on June 17th. Would that help you remember this topic? Would. You're dropping ice cubes into their drinks. You're refreshing them. You're getting them ready. They read it. They flip it over. Did that help you refresh your recollection on this topic? It did. Now, going back to it, what was the answer to my original question? So you can always assist someone's memory. You can use individual ice cubes in this way. But notice the difference between prior and consistent statements, refreshing recollection. We're able to take little instances where our witnesses forget and where their witnesses may lie or testify inconsistently. The hearsay exception of former testimony, it's a whole different animal. That's when we're trying to find a suitable substitute for the whole testimony. We're going to take the giant ice cube, pick it up from one trial, if we satisfy the foundational requirements, and plop it into our trial wholesale, full on. Those are the times when you get to go to a witness's prior statements. Otherwise, if we don't hear the magic words of I don't remember, if people don't testify inconsistently, if they're not unavailable for trial, they're right here alive in the flesh, then we're going to have a contemporaneous conversation with that witness that's informed by prior statements, but we're not referring directly in our questions to prior statements. So here they are. Here's the 3 uses: former testimony, prior inconsistent statements, refreshing recollection. Good luck.